Welcome to the Plan Grow REIT podcast.
Welcome back to the Plan Grow REIT podcast. I'm Sammi, and today I'm joined by one of our associate lawyers at Aintree Group Legal, Mr. Liam McColl.
Hey, Sammi.
Today we'll be covering everything your dispute lawyer wants you to know.
Thanks for having me, Sammi.
So, Liam, you've got around 6 or 7 years in disputes and litigation. Would you say most disputes are preventable?
Yeah, absolutely. I would, Sammi. I think a lot of the disputes I've seen have been preventable. Or, of course, not all. Sometimes there's always going to be an impasse between one party and another. Different people want different things. There's always going to be different objectives, and do the ends justify the means, et cetera, et cetera. But usually, I would say that on balance, most disputes are actually very preventable.
All right. Well, given your experience in the area, what issues do you come across which you feel are responsible in escalating conflict?
There's quite a few, but I think one of the most common ones is either going to be poor communication when there are two parties to a commercial agreement, and that could be something that's verbal, or it could be contracts that have been drafted which are unclear or silent on certain obligations between the parties, and it can cause a lot of distrust between them, and relationships can then break down. And as soon as you've got one party not wanting to do something, or the other party not doing it to the way that the other party expects them to, when they've all got their sort of predetermined idea of what should be happening in an agreement, you come to a point where that escalates, where there might be one small matter. It kind of escalates and snowballs into a much bigger issue, and that escalates the conflict, and you always break it down, and you kind of get both parties in a room eventually, if it ever goes that far, and you kind of see, well, one party is interpreting this contract in this way, the other one is that way, and you can clearly see, I can see why both of you would be at this impasse, because this contract is very unclear on the certain duties and obligations of the parties. And the one way that it could have prevented that is really clear communication between the parties, or a contract which is clearly written to be able to prevent that.
Would you say there are any other key early intervention strategies?
Yeah, of course. As soon as something like that happens and the parties are able to identify an issue that is arising between them, communication always plays a really key role. And usually it could be the case if they can't resolve it between themselves, then people like me get involved. And there hasn't been that often, but often I do see that someone has come to me and they said, look, we're not really in a full-blown dispute yet. I'm not asking you to sue someone, but I would like you to tell me what our options are. And it could be that, look, I identify the issues, and then I might write to the other party on behalf of the client and say, look, there's a bit of an issue here. We know there's a problem. We need to resolve it. So before this goes any further, do you think that this is something we could work on? But of course, it kind of scares people off when when the other side has hired a lawyer to talk to them. But usually there can be also a lawyer on the other side, or if it's a big company and they've got legal counsel, you can usually try to get really ahead of it before it goes even further and say that we need to work this out now before we spend unbelievable amounts of money on legal costs trying to litigate in the future when the problem becomes bigger. And that's a really key one, is communication, to say that, okay, well, there's an issue. Perhaps me as the individual can't solve it, but perhaps a lawyer can, who's experienced in doing so.
You talked a bit about how litigation obviously involves quite substantial costs, and I think the implication there is also time. Are there any other maybe pathways that clients can look towards if they're not going towards litigation?
Yeah, of course. And one of them is what they would sort of refer to as alternative dispute resolution. That can be mediation, you can negotiate between the parties, or even to the point where it's a telephone call between the lawyers to sort out what's going on. And it's always key to do it as early as possible, because then you can narrow the issues that are in dispute. Then you can get everyone into a room, to a table, and sort everything out before it goes even further. And I can understand that some people are hesitant to do so because they think, I'm not going to hire a lawyer and spend money on a mediation. But as I say, that an ounce of prevention is worth a pound of cure. It could be far more expensive than going through a legal process where you need to mediate in the future, and you'll have spent thousands upon thousands of dollars getting there.
Do you find that clients are usually reluctant to go towards alternative dispute resolution processes, or do you find that they're usually all right and they'll take in your own opinion when it comes to exploring other pathways?
Yeah, it kind of depends what sort of frame of mind they're in and how long the dispute has been going on. Usually, if we're at the very start, I find that everyone is quite amenable and they think, look, great, mediation is always the way to go. And every lawyer will tell you that, mediation, if the parties can see eye to eye, if the issues are narrow enough that they can identify that what needs to be done, and the parties have a clear pathway forward and they say, yep, we can absolutely meet in the middle, then it's great. There are other times where the dispute has gone on for quite a long time and the relationship between the parties have broken down. They don't really want to talk to each other, and you get to almost a point where they don't really want to give an inch really about with their position. They kind of say that, well, I don't really want to talk to this person. I don't want to be in a room with them. The only way that we can sort of force them to see our side is to begin litigating. But it really depends on a number of factors. I always push early for it, and I always at least try to, if the other side has a lawyer, to talk to them before we really go any further.
No, that's always good to hear as well. Would you say that in the case where the parties where maybe you haven't gone in early and maybe the parties have already had their relationship break down, when it comes to litigation, can you maybe talk us through that process and what that would involve?
Yeah, so if there are times where the parties don't want to resolve, well, it's not that they don't want to resolve their issues, but rather they just can't, then litigation is always the path, the least desired path. It is always that sort of this is the last step that we can really take. There's no alternative. And it's an expensive process. It truly is. And I always make clients completely aware of it, that when they're sort of trying to resolve conflict early on, they kind of sort of say, well, I don't want to give the other side what they're asking. I don't want to do this. I don't want to do that. I want to remain firm in our position, which is completely fine, and sometimes I can understand that. But you also have to advise them on the risks, and the risks comprise mainly of what they can be exposed to, but also the cost. And the court system is not cheap, and depending on the nature of the dispute, for something that's under if we're talking for a civil claim, under $100,000, you're going to be in the magistrate's court. Over $100,000, you're either going to be in the county or Supreme Court. And the more expensive your claim and the more higher up the court is, if you're going to be in the county or in the Supreme Court of Victoria, the more expensive the filing fee is going to be. You're going to be having, you're going to be before judges. There's going to be very strict deadlines for filing and other key events, going through discovery, any interlocutory steps and pleadings, and it's all, the costs get pretty expensive pretty quickly, and you always have to make them aware of that, and you say that, look, happy to file a claim. Let's say it's you're suing a company for $1 million that you say that you lost. There's been financial loss of $1 million. I say, okay, well, we've got to file a writ and we've got to file a statement of claim. Then we have to see the other side's defence and then maybe a reply. If we see that as necessary, then you've got a directions hearing, which will set down the next steps. It's sort of the directions give an outlay of the future conduct of the proceeding, which could comprise discovery. It could comprise further and better particulars. All these other interlocutory steps usually up to at that point mediation. And that could be only a 3 to 4 month process. And I say that, look, the first part is pleadings. You put in your statement of claim, you receive a defence, you consider it, and whether you want to put in a reply, or if they counterclaim, then you've got to defend that. And I mean, that is the first step in this proceeding. And it might only take place over the course of, say, 2 to 3 months at most. And they kind of think, well, that's a really short time frame. But then you just tell them, that's going to cost you tens of thousands to even get there, especially for this matter, depending on how fleshed out or how involved that pleading process might be. And it's and at the end of the day, after you get through that process, you're going to end up back in mediation anyway. So you're going to have to be at the table. So that's something that I'd always like to let them know is like that's the process from the outset. That's where you'll be. And to get there, even to get them to the table at a mediation, you're going to be spending a fair bit of money.
So obviously it's a taxing process in terms of money, and you're also saying time. Are there any other areas in which the client might be involved in? So obviously if they've got legal representation, you'd be assisting them with the court proceedings and such. But when it comes to them, is there anything expected of them? Anything that they sort of have to produce or have to do to assist the claim?
Absolutely. The clients can't necessarily just, sit back, take a step back and think, well, my lawyer's going to handle it from here. The claim has started. I guess I'll just pull up a chair, put my feet up and just wait for it all to be done. Parties get very, very involved in court proceedings. We will need constant instructions and we will need them to then, especially in discovery, which is a very, very involved process of the process of the parties giving over and producing all of the relevant documents that are relevant to the dispute. And it doesn't mean just the documents that they might think are relevant, which may suit their case. It's everything. It's documents that might assist you, documents that might hurt your case, and it's both. And it's absolutely everything is on the table, and it's expected of both sides, and then they exchange. And I've been in discovery processes with clients that's gone on for months, and they sort of said, "Oh, got to go get this document and that document," and we kind of tell them, like all invoices, all receipts, all statements, all communications. Do you have copies of these written agreements? Have you got photographs of this? What did you say to that person? What did that person say to you? Do you have purchase orders? What have you got? Just absolutely everything. And they kind of go, oh, I don't know, like that's so much. Like, where am I gonna? I'm gonna have to trawl back through my emails, and I'm gonna have to go and look to see if I've got hard copies of receipts, or it might be in storage. I need to go get in storage, and I say, yeah, you absolutely do. I'm sorry that it's a pain, but you absolutely have to give over absolutely everything, because the parties need to know what documents there are, because it is critical to resolving a dispute. And critical for the parties to narrow those issues, and you can only do this by discovery of documents. And the relationship that you end up having with your client when going through a court proceeding, you end up becoming quite close. It's almost like a bit of like a trauma bond in a way, because you're having to go through all these documents, and they give you this and that, and then you find there might be another document. You're like, well, do you have that? And they go, okay, oh yeah, I've got this document. And you're like reading through it, and you're like, oh, well, this mentions an invoice back from June 2023. I haven't seen that. Do you have that? And they go, oh, I have to go back, and then they find that. And it just becomes so involved. And it's like, yes, I am advising you and might be drawing documents on your behalf, but I'm doing it with your instruction and your involvement about what you can provide me in the matter. And the more that you can provide, the better it is.
You sort of take on like a backseat driver role, where they think that you're in control, but really they have to be doing a lot more still.
Yeah.
Obviously, no one wants to find themselves in the middle of a dispute. But that being said, you talk about document discovery and that entire process. Are there any record-keeping strategies that you think clients might want to keep in mind?
Yeah, of course. And if you're running a company, I mean, obviously your record keeping is going to be hopefully pretty good, and it's always just absolutely keeping everything. It's not sort of getting a hard copy of an invoice, paying it, and then throwing it in the rubbish. It's always just absolutely keeping everything, keeping it filed away, so you know where it is in case it has to be called upon. Of course, during litigating during a litigation process, it might be quite difficult, but if you are in a commercial contract with someone, it's always just really good practice for everything you do. You should keep it and record it so you know where it is. Make sure it's to the best standard. If you've got an accountant, get your accountant involved. You've got a financial advisor, get your financial advisor involved. Even then, if you've even got a lawyer who's helped you draft a contract, and you say that, look, here's all this record and documentation. I know that even Aintree to an extent keeps a lot of like records on file. So it's the best that you can do, because the more that you can produce later on to help you, the better it is.
No, that makes sense, and I'm sure clients will be happy to hear that. Just to finish off, is there a final thing that you want clients to know about litigation?
Yeah, it's expensive. And it's, as I said before, ounce of prevention is far better than a pound of cure. And there can be times where you've got to understand that, sure, I may not want to, my lawyer said, look, it's going to cost me $3,000 to $5,000 to probably have a pre-mediation or a pre-discussion with the other lawyers to resolve this dispute. I don't really want to spend that money because I think the other side is at fault, et cetera, et cetera. And I can say, sure, but if this dispute keeps on going, you're going to be in court. You're going to go through the processes. And you're going to go to mediation. And after mediation, if it doesn't settle, you're going to keep going. You're going to go all the way to trial. I can absolutely guarantee you that money is going to blow out even further. And if you're not successful, then you could be liable for paying even the other side's costs. So it's always a case of letting them know of the cost implications of resolving as early as possible. And if you can identify a way forward, then that's great. If you have to compromise a little bit, it's far better.
It's worth it.
Than spending tens, if not hundreds of thousands of dollars in litigation. But sometimes litigation can be the only way forward to resolve a dispute where the communication and the relationship between the parties has completely broken down. And that's understandable, and it does happen. But it's also that I think it's don't know the statistic at the top of my head, but I believe it's around about 10% of cases that are commenced go through all the way to trial, which means that 90% of cases, give or take, resolve before trial. And so it's important to remember that you can resolve at any time. And if you want to identify a moment as early as possible to do so, you should.
Oh, that's good to hear. Thank you for your time today, Liam. It's been great. I'm sure our clients will also appreciate your words of advice.
Thanks, Sammi. It's been a pleasure.
Thank you for joining us for this episode of Plant Grow Reap. Thank you to Liam especially for sharing his expertise with us and the listeners. The next episode in our series on what your lawyer wants you to know will be all about property law. Subscribe to us wherever you get your podcasts, and we'll chat again soon.